let's talk about something that happens way more often than it should: slip and fall accidents. According to the National Floor Safety Institute, over 8 million people in the US head to the ER each year because of falls. Slips and falls alone account for more than 1 million of those visits. That's about 12%, and we're not just talking about minor bruises here. These accidents can lead to traumatic brain injuries, spinal cord injuries, and long-term health complications. Now here's the thing, not all of these incidents are just bad luck. A large number happen because someone else was negligent. And when that's the case, the law says the at-fault party can be held responsible. If you or someone you love has been hurt in a slip and fall, especially because of unsafe conditions on someone else's property, you might have the right to seek compensation. So let's break down what that looks like. There are 4 key elements that need to be present to win a slip and fall settlement. Duty of care. This means the property owner had a responsibility to keep the place safe. They're supposed to look for hazards, fix them, or at least warn you about them. Breach of duty. This is where something went wrong. Maybe they didn't clean up a spill, or they failed to repair a broken step. If they ignored a safety issue, that's a breach. Causation. You have to show that the hazard directly led to your injury. And not just that, it had to be something the owner could have reasonably foreseen might hurt someone. Damages. Finally, you need to prove that the fall actually caused harm. That can include medical bills, lost wages, emotional distress, or even long-term disability. And when it comes to settlement amounts, a few big things influence how much a case might be worth. First up, how bad the injury is. More serious injuries mean more medical care, more time off work, and unfortunately, more pain and suffering. For example, traumatic brain injuries or spinal cord damage can lead to permanent disability, loss of independence, or even difficulty breathing or working again. Then there's the defendant's level of negligence. Oklahoma follows what's called modified comparative negligence. That means if you're partially at fault, like if you ignored a wet floor sign, your settlement could be reduced. And in rare cases, courts might award punitive damages. That's not to cover your losses, but to punish the other party if their behavior was especially reckless. Look, proving all this isn't always easy. It's complicated. But that's where the legal team at BDIW comes in. They've got over 65 years of combined experience and a solid track record of helping clients win fair settlements. So, if you or a loved one has suffered a slip and fall injury, don't try to navigate it alone. Reach out for a free consultation. No pressure, just honest answers about your options.